Good morning and good afternoon, everyone. Welcome, members of the Cyber Risk Alliance and friends as well. Welcome to our briefing today entitled "A CISO's Guide to the SEC Cybersecurity Regulation and CISO Liability." I'm Tom Skura. I'm the moderator and Vice President of Content and Programs of the Cybersecurity Collaborative. And I'm joined today by two panelists, Jane Dombowski, who's the Chief Information Security Officer of OneMain Financial, and Donna Ross, EVP and Chief Information Security Officer of the Rating Group. Unfortunately, Ajay Gupta had some other obligations today and won't be able to make this particular presentation. So I just want to remind everyone, please take advantage of one CPE credit for your certifications by attending here today. This presentation is available to all Cybersecurity Collaborative members. And those who are non-members, it's going to be available to you in the chat box. We have a way for you to contact Tom Ward, and Tom will send you the presentation. At the end of the presentation, his email address will come up as well. I want everyone to recognize this is chock full of information. These slides are mainly because we want to provide some value. When you have the slide deck, there'll be some good things that you can take back with you. And clearly, I'm going to cover some key points and make sure we avail ourselves of the time and experience of our two guests who are well-versed and really contributed greatly to this team and to this presentation. I do want to briefly introduce our two guests. Jane Dombowski, OneMain Financial, has been offering responsible and transparent loans for over 100 years, so it's been around for quite some time. Over 1,500 locations, throughout 44 states. It helps people with their personal loans, and OneMain company and its team members are dedicated to communities where they work and live. Jane has had over 20 years of experience in cybersecurity. Interesting background. She's been a special agent in positions within the FBI, also international cybersecurity experience as acting legal attaché in cyber for the FBI as well, training people overseas. She's also been with SC Johnson and Deloitte. She's been the recipient of the Attorney General's Award for Distinguished Service. She is a lawyer. So anyway, she'll help me through this and make sure I'm consistent and correct.
Tom, this is where I have to say none of my remarks should be construed as legal advice.
Yes.
Nor, and no attorney-client relationship is explicitly or implicitly created by today's discussions.
I'm glad you said that. I was going to say it, but you said it much better and much more authoritatively. I also have to say, though, interestingly enough, you've had experience with botnets, DNS tools, DDoS, and basic cyber security investigations, training cybercrime investigators throughout the world. So, anyway, Jane is well versed in this and a lawyer as well as being an adjunct professor for cybersecurity law and ethics at Purdue University. Thank you, Jane, for joining here. And also joining us today is Donna Ross, who's a CISO of the Rating Group. That's a mortgage insurance company offering a suite of mortgage, risk, real estate, and title services. Its roots began in 1977 as the Commonwealth Mortgage Insurance Company, later become Radian in 1999. I've known Donna for quite some time. She is a very dynamic leader. She's been on a number of boards with over 20 years of diverse risk compliance and information security technology experience in multiple sectors. She's been an experienced leader for not-for-profit boards. She's been on multiple leadership advisory boards as well. She's had information security management positions for GMAC, Corning, and Accolade as well. She holds 10 security certifications, which is quite impressive in a number of different areas. And she's very well versed in information security risk management, Sarbanes-Oxley, compliance, disaster recovery, business continuity, and project management. I've known Donna for quite some time, and I know that many of the solutions that Donna has provided for her organization and to those as members of the Cybersecurity Collaborative are practical, workable, and really get at the heart of addressing risk. So thank you both, and thank you both for sharing members of your team to be with us in the Cybersecurity Collaborative. Their expertise has helped in a number of different areas in security metrics and operational technologies, a whole host of different things. And that's the one thing. I mean, you are giving back to the community by being here yourselves, but also sharing your best practices of your companies with your teams. in our collaborative call. So thank you very much again. Just briefly, for those who aren't.
Let me add as well that
There you go.
that this is not meant to be advice. So this is really the opinion. I'm not representing Radian. So as we go through this, keep in mind that this is just our thoughts based on our experience, but it's not meant to be advice, and seek your own counsel internally for your companies.
I think that's very important. If you're here as a CISO, you're getting the benefit of how members are approaching this. But I think we just talked about every company is going to define things differently based upon your risk tolerance and what your legal people provide. So we need to obviously keep that in mind as we're going through this. The Cybersecurity Collaborative, for those who aren't familiar with it, is an organization meant to benefit both CISOs and their staff. For CISOs, the first thing you get in the morning is the daily morning security report. You never go into a meeting with someone says, did you hear about a cybersecurity incident in a certain company? How are we responding to it? You get that at 6:30 a.m. in the morning Eastern time, and you're prepared right away to be able to address questions from your management and also ask your staff, are we dealing with this incident and so forth. But there's more to that. We have CISO power hours twice a month where you and other CISOs can get together and discuss issues you're facing, staff retention, staff acquisition, et cetera. We also have a library of over 200 CISO developed tools and resources. And we have task forces. These are groups of CISOs and their staff that get together on specific security topics. This is one of them, but there are several others that I'll share with you as we go through this report. So remember, it's a great way to learn from other members of your organizations. We're third-party neutral. We have third-party providers, but they aren't providing advice and guidance for us. We do discuss the use of tools, which ones work, which ones don't, how are they working for us. But we're not governed by, no one's paying for our membership here and promoting a tool for their benefit at these sessions. So let me move through the agenda today. So it's really two parts of this. We'll give you a little background on the task force and what this is. But the focus today is going to be on the SEC cybersecurity regulation. And I'm going to run through the applicability, who does it apply to, and the requirements. And I'll show you an example of how a company has responded. We thought was a good response to a 10K, and we'll show an 8K response as well. But then we're going to go into compliance guidance. And again, it's not legal advice, it's guidance on how we suggest you and your company approach it. You're going to make different decisions, but I'm going to ask my panel to really weigh in on some of the guidance that came out of this particular task force. We are then going to show you some of the supporting resources that we're offering in the Cybersecurity Collaborative. This is an ongoing journey as we learn how members are filing and the SEC is responding. We're here together learning collectively over the course of the year. We have meetings once a month on this topic. The second area which attends this is the CISO liability issue. The SEC regulation has always been a liability, but that sort of heightens the question about what liability do we have as CISOs and how can we mitigate that liability? How can we address it? So we'll discuss what that is, but we have some good ways that you as CISOs to really pay attention to ways in which you should really protect yourselves as you're protecting your organizations. And then we'll conclude with the cybersecurity collaborative initiatives and key content, and then a Q&A at the end of the session. All right, let me move on here. Oh, this is where I put the disclaimer in. A little late, folks. This is guidance from the task force of CISOs. It is not legal advice, okay? So, but use it. I mean, I think you can get some good things out of this. So I'm going to ask Donna and Jane to share your personal experiences with being on this team. Again, task forces, we call them task forces, really deal with a cybersecurity topic. We meet weekly, generally, and if we like to continue meeting on this topic because it's of import, we'll meet on a monthly basis as we're going to be doing here going on. But you can see on the list on the right-hand side, we're not industry specific. And we find that we get value from learning about how other companies are responding and developing their cybersecurity programs. We learn from each other. I have to say, for example, we have one member that's a big university with tremendous cybersecurity practices, and they're on our team calls, and they share those and then offer their templates to us. So it isn't just industry, it's education, it's government. We all come together to share our best practices. And we're a collaborative organization, but members do share their policies, procedures, and templates. We anonymize them, of course, but that's part of the value. But let me just ask you, Jane, and then Donna, what did you think of this team? How did it help you? And we certainly know the contributions you've made, but what did it help you in your journey with this SEC regulations?
So I think Donna will agree with me that in terms of the confidence that we have when we agree to what's going to be final in the 10K, it really helped us because we did go through and analyze, and everybody in the audience today, and thank you so much for attending, will see how we analyzed 10Ks and 8Ks. And having that confidence to move forward is excellent. The other thing that I would point out, that what we were able to do, and Tom, I kudos to you for bringing this person in, is that we actually got to talk to somebody in the insurance industry, and being able to talk about the difference between D&O, directors and officers insurance, and E&O, errors and omissions, and understanding what covers a CISO or what might cover a CISO and what doesn't cover a CISO. If for me, on a very personal level, being able to have that understanding or increase my understanding was extraordinarily valuable. And I hope we can cover all of that during today's discussion.
Thank
Thanks,
you, Jane.
Yeah. I'd agree with what you said, and I think the one thing I'll call out on this task force that we didn't talk about is we represent such a broad and diverse group. You know, we had publicly traded companies and non-publicly traded companies. We had small, medium, and large. We had different industries, different sectors. So if you think about cybersecurity as a whole, the way we solve complex problems is through diversity. And that's exactly how we approached it on this task force. And by taking these diverse sectors and experience and individuals, we were able to accelerate problem solving for this very serious problem with this new reg. We're able to, as Jane said, promote a shared learning and reinforcing for each of us, you know, that we were on the right path. And I think in the end, we're going to share what we developed in this deck is kind of an innovative solution that'll help all of you if you're going through and, you know, doing your 8Ks or doing your 10Ks, so you can maximize the individual efforts that folks put into this team. And I know I, for one, appreciate everyone's efforts on this team, and I learned a lot.
Well, thank you both for those comments. What I'm going to do now is talk about the regulation. Where does it apply and what the requirements are? I'm going to walk through this quickly. Again, there's a lot of material on these slides. Everyone is entitled to a copy of them. So here are the main points from my panelists today and key points that I'm raising in this. And again, you can read this to reinforce these points at a later point. The obvious thing is it does apply to all publicly traded public companies where stocks may be bought and sold by the general public. The SEC regulation, if you want to get a hold of it, your lawyers probably already have, and I looked at this in depth, but just so you know, you can go to the SEC Gov site, look for the final rule, click on that, and then read all the language within the final rule. So it's publicly available to you. It really addresses reporting requirements of the 8K and the 10K. And the 8K associated with material incidents, that's a word you're going to hear over and over here today. And when we talk about our guidance, we'll share our guidance in that area with you. And so the 8K is reporting of events, and as Donna said, the 8K is nothing new, nor is the 10K, but So we're going to talk a little bit about that. It's about the reporting of that, but there's more than simply just reporting. It's what you report. And again, the crux of this is defining material incidents. And we're going to talk quite a bit about that. It was adopted mid last year. In terms of the reporting requirements, the 10K annual report now has a separate section called 1C Cybersecurity. So it's called out. And now for fiscal years ending on or after December 15th of last year, you're required to fill in that section. And we'll go into the details of that. We're going to show you a really, good example of a company that put this together and why we think it was good. But again, you have to talk about processes for assessing, identifying, and managing material risks. The board's oversight of those risks. How is it notified? Do you have any subcommittees associated with that? And then management's role in assessing and managing the risks and threats. With regard to the 8K, which is significant events important to shareholders, disclosures of material or likely material. We'll talk about this. And you'll see in some of the 8Ks that some of them are likely material, but there are some now being reported as material. Incidents starting as of December 18th, 2023. As an item 1.05, but there's another place that you can report these that some are doing as well. And of course, there'll be amended filings to this. So something may not be material and you're working on it, you're going to do an 8K amended filing to report on progress. And then of course, if it becomes material, you'll need to report on that as well. So I'm not going to read the regulation language, but just to summarize on the left what is written on the right. 2 points to this: risk management and strategy and governance. Those are the 2 things that you need to report on. Not necessarily in that order, we'll see, but you need to cover these parts to it. So you need to describe your assessment, identification, and management of material risks. That's a mouthful right there, a lot to say, but you'll see an example on how they do it, which is pretty good in defining it in sufficient detail for a reasonable investor to understand. Again, your legal team is going to have to interpret this. There's not specific criteria to be able to do that. You have to talk about integrating it into your risk management system. So you really want to know how you're handling risks. And certainly we do risk assessments. You might have an enterprise risk management organization. These are all things to call out. But they do also ask whether or not you're using assessors, consultants, and auditors. So obviously, if you're ISO certified, PCI, some of that can come into play. And they want to know also about how you're handling third-party risks. Your use of third parties to process your information, whatever it might be, everyone recognizes those risks. So how are you managing those? And then again, if you've had materialized threats, so a lot of these 10Ks perhaps are being put out now won't have materialized threats in them, but maybe a year from now, some of them will have. And again, what's the impact on business strategy, operations, or financial conditions? And you have to consider the impact of previous cybersecurity incidents that all of a sudden collectively do become material. That becomes a little bit of a challenge. The second part is governance. Again, text on the right, key points on the left. They want to know about the board oversight of risks and whether or not you have a risk committee or subcommittee. It's interesting that they kind of call it out. Many do, it may be audit committee of the board, but maybe the members have a special committee designated to address risks. And they want to know management's role in assessing and managing material risks. The description of relevant expertise. Now, this is an interesting one because the example I'm showing you, it's only one sentence. So, how much you put in this one example was very short. Informing management committees about incident prevention, detection, mitigation, and remediation. Again, your incident response plan is calling out, and management's reporting to the board or the subcommittee of risk. How do you do that? How often do you do that? So I know, Donna, you provided this to the team. This is Lockheed Martin's example. It's public. And we took this as an example of again, people can look at the length of it, what they're saying, and the structure of this is a model right now of how to respond. Again, it's up to your legal team and how you're going to do this, but this is, we can learn from this. And again, we're going to be looking at these in our task force as we go forward throughout the year, and maybe we'll come up with a better model. Maybe we'll come up with a common model for the task force. But this is, this has just happened. So the opening statement on this, which is interesting, it's nothing to do with what's required in reporting, right? I mean, it's affirming the criticality of cybersecurity, recognizes threats, notes that these threats also occur to our customers and suppliers, and establishes the need to lead and invest in cybersecurity, right? So what it's saying, I think the company is saying, yeah, we know we need to do this. We have these risks. They're not just ours, but they're ours associated with the people we work with, customers and suppliers. And so it's a good way to start. It's not required specifically, but it kind of is a good way to start. And I'll share the closing statement in a minute too. So what they do is they don't follow, let's get into the risk management process. They talk about governance first, okay, which is fine. No one says there's a specific order. You just have to include the content. This describes the board's risk oversight role. It introduces the CISO's role to regularly brief the board on information security posture and moderate high incidents. A subcommittee is referenced in this that addresses this. They name it specifically. And it also references and describes the incident response plan, including notification to key stakeholders. So we do talk about risk in the context of the board, how the CISO works with the board, how the board is informed. And the engine that really deals with this goes back to the incident response plan as being key. And we're going to come back to the IRP a little bit. Then they talk about the management side. And it cites the information security organization and some of the key functions, right? That you might see in a typical organization, but it doesn't say I have 10 people and this and 5 and that and whatever I'm going to do. It says these are the main functions of the organization. The interesting thing about it is, as a CISO, it has this one sentence on the CISO that I can see. Extensive information technology program management experience and has served many years at corporate information security organization. Okay, so doesn't say how long I've been doing, what other companies and that sort of thing. They just kind of said, yeah, we have an experienced CISO handling our business here. It mentions the role, again, of the incident response team, calls out CERT, common term in incident response, for protecting detection and response. And it attributes the security role of employees outside of the information security organization as well as something to help us with their cybersecurity expenses, cybersecurity response. So they're talking about any employee who might report an incident, something that happened, they report it to the security organizations. And they make it known that it isn't just the security organization that has this role and responsibility. Then here they delve into the risk management process. They talk about risk governance and processes for cybersecurity risk. They know counterintelligence and insider threat detection. So they're telling a little bit about some of the capabilities they have. In two ways. One is the counterintelligence, and the other is intelligence-driven defense. We're all familiar with the Lockheed Martin kill chain, and perhaps that's what they're referring to. And they describe the regulations with which the organization must comply. So they are showing that, yeah, we are under some scrutiny. We handle control unclassified information, NIST 171. And we go through a CMMC program to see how mature we are in handling that information, because they work in the federal space. So it could be if you're PCI or you have NYDFS or whatever it might be, maybe it's worth mentioning there. Again, depends on your organization and how they want to do it. Then they talk about third parties. Now, third parties are talked about in two respects. One is the third party that you use as part of your cybersecurity program. They're typically auditors, pen testers, forensic specialists. So they do mention that we do use them, and they also should receive threat intelligence as well. They talk about that again. In paragraph 6, they then move on to talk about enterprise risk management processes, risk owners who develop mitigation plans. So they talk about, yes, we have an enterprise process. We have an annual risk assessment. Most people do if you're under some kind of compliance obligation. So they do mention that. And they, as I mentioned, they note that we are tracking mitigation plans based upon these risk assessments. Before the second to last paragraph, they do talk about third-party risks. Now, this is interesting. They've spent a lot of text talking about third parties. And the entire record actually supply chain risks, use of the cybersecurity questionnaire, PFARS requirements, the monitoring, using third-party monitoring services. That's probably BitSight or Security Scorecard. Offering cybersecurity education awareness materials to their third parties. And I'm going to have to kind of move on because we're running out of time here. And then the closing closing remarks really, you started, it's important. Now we're saying we may not be successful in doing everything. We do have cyber security insurance. They may not be fully insured, and then they have another section on risk factors. So summarizing this, and Donna, this is your assessment: ease of access. They nailed risk management and strategy, border oversight and cyber risk. They did a pretty good job as well. And management's role in material cyber risk. They've done this in 8 paragraphs of varying length.
Yeah, I think one quick statement here, Tom. It's very well written, certainly a model for folks to follow. It was very detailed, so I would caution people, if you're going into that much detail, think of it like a SOC 2 report or perhaps a SOX audit, that for every one of those things mentioned, that you have controls and evidence to demonstrate the efficacy of those controls. So that would be the only thing I'd call out in that. But again, very well done. It's a good model for anyone.
Good.
And if I could also address one of the questions that was posed to us, it was Paul Alvarez who said, I thought the rule said disclosures needed if an incident is found to be material within 4 business days. Where do they consider likely material? The actual language used by the SEC is reasonably likely to be material. And you've got to include that in your 10K as well. If you look at the opening statement that Lockheed Martin made, they actually listed some threats that could be reasonably likely to create a material impact against the company. And you're going to see in the 8Ks that get filed, a lot of people do not state that this is material right now. They say something like, we don't believe it is material at this stage, but it is possible that it could become material. So hopefully that answers your question, Paul. That's actually in the regulation. And then Michael made a really good point about what is material. It's a point that Tom and Donna have already made, but I think it's worth double tapping on, which is that everybody needs to determine materiality for themselves. Donna mentioned that we had all different sizes of organizations on the task force. And because of the different sizes, the different market caps and all of that nature, you're going to have a different materiality determination. One of the things that we did was we ran an executive tabletop to talk through materiality and what would be materiality. And I highly recommend that for those of you who are publicly traded, are dealing with all of this, that you do that that's sort of an exercise. All right. Can you comment on which liability risks the CISO personally may have and the appropriate insurance coverage for CISOs?
We're going to get to that.
I tell you that
we're
we'll get to that.
Yeah.
Why don't we finish
I'm
up
going to
the
move
8Ks
along
and we'll
a little
get to
bit.
that.
Yeah, I'm going to move along a little quicker because I think it's important. Thank you very much, Jane, first of all, for those insights, and great question as well from our panelists. I'm just going to go through this quickly on the 8K. You can read down the right. no unreasonable delay for determining materiality, 4 days of determination, no need to disclose specific technical information about planned response. And I'm just going to show you this example. We actually are putting collecting these in a book. In fact, you can do a download just to kind of look and see how people are responding. This is one First American. I just pulled it out of our resources. Again, just to give you an idea of the length of what they're saying. They're talking about the date, some details, some actions taken, some restoration activities, some impact, not a lot. They are referencing a site that people can go to. And here we haven't determined this material. In a subsequent filing through the Christmas holidays, at the end of, right before the new year, they give a little bit more information to say, well, that could be some exfiltrated data, encrypted data, et cetera. We still are not sure it's material. All right, just to give you an example of that. And I want to move on to materiality. And I'm going to go through this. I'll share this model with you. I won't spend a lot of time, except we do want to talk about materiality and let my panelists address that. But you have to, it isn't just writing, 10K and 8K reports, as we know. You've got to really address materiality according to how you want to do it. Now, the benefit of being on this team is you're going to get some guidance from others to see how they do it. It doesn't mean you should do it that way, but you can see how we're all dealing with this. And we're going to be analyzing, 10Ks and 8Ks to see how other companies are doing as well. That's the advantage of being in a group like this. But regardless of whether you're not, you need to establish some kind of an oversight body, and I'll go through that very quickly to address this, okay? It could be part of an existing body, but it really has to be something you have to pay attention to and spend time on. You need to define materiality and spend some time on that. You need to integrate this within your incident management processes, because your incident team needs to know whether it's a SAV 1 or whether this could be potentially material. They need to recognize that we're under the gun to report that. And there has to be a reevaluation process. So in other words, go through and look at the 8Ks that are coming out, test your definition. Would we have considered this material or not? Again, you may not change it, but it's good to get some insights. Maybe you have an auditor come in and look at that as well. So I'm just going to skip through this. You'll all get this in the slides. This shows you an example of some members of a particular committee and some of their responsibilities. Let's talk about, I'm just going to talk about materiality and how we do it. So the first thing I've gotten wrong here from our lawyers here is that CFO does not necessarily have the final say in all situations, okay?
That's
Very
correct.
much depends on your organization. I stand corrected on that. In some organizations, that's true.
In some organizations, they have a key role. I mean,
Right.
the financial organization is used to making a determination about financial materiality, and that does play a role here. But what the rules have stated is that you need to, it's not just the quantitative, it's the qualitative as well. So you're looking at reputation, you're looking at, disruption to business operations, not just from a financial perspective, but from how does that impact your clients, your customers. And you have to think of it from the terms of the whole purpose. What the SEC is trying to do is get out information so investors can make good decisions. And if you start from that understanding, you can think about things like competitiveness. Is this going to hurt our competitive stance? What does this do to our valuation? Things of that nature. So I think that that's all incredibly important.
Very, very good points. And we've listed a whole bunch of things on the right that factors you can consider. One thing that came out was the FAIR model, right? Someone said that there's a FAIR maturity, not maturity, I think I've misstated that, materiality assessment model. Sorry for that. That you might be able to use as a way to justify that. I'm not familiar with that. That may be something that we may look at in one of our meetings and have it demonstrated. one member said there are 4 criteria. I'm looking at the bottom left: operational impact, number of records involved. I may have a set number of PII records, or whatever it might be, a loss amount, and then triggering other processes that are significant, crisis processes, business continuity, DR, was, one way to do it. Now, what you have to do is you have to dig into that a little bit more, like define operational impact more specifically. If it's an hour, is that material? If it's a day, maybe that's more likely to be. If it's 5 records, if it's 600,000 records, right? I guess and again, that's up to your materiality committee and legal department. So this is something we continue to discuss. We're evaluating responses in the 8Ks, and again, we will have members share how they're developing these things and look at some models that are out there that may be useful. I'll run through this too, because I know we've got to talk about CISO liability. A lot to cover in this session. You need to integrate this within your incident management processes without question. You need to, again, if you define it as a SEV 1 is incident, then, then on the right, it triggers notification to the CISO in consultation with others to determine it, then determine the materiality. You're going to need more stringent time tracking on these things too, because if someone comes up and says it was without unreasonable delay, you want to show that you've spent time on it. Like, we're going to, when it happened now, we'll wait till the next monthly meeting, maybe too long. And there's also a 4-day reporting to the 8K. And the last thing, and I think, Donna, you were talking about this, is reevaluating this, right? I mean, really testing this concept. I mean, you may have a initial concept of materiality, and you may find that based upon what's happening in your organization, others, that maybe we're too stringent, maybe we're not, right? I think you have to go back, and again, we're looking at the 8K filings, and people are now testing their definition of that.
And I think this is one of the most important things that we've talked about. So, create your matrix, create your process, your workflow, and then, as Jane said, do tabletops. Test it on your previous incidents or events. Pull down 8Ks from other companies, test it against those, roll up previous things in any way you could test and validate, and then just do what you say you're doing. So create the process, create the workflow, and then do some testing. And I would say any agency would be hard pressed to find someone deficient if they did what they said they were doing. They may not be right 100% of the time, but I think it could be significant in the future. So create your own matrix, or stay tuned with us as we continue to do those. These filings are available in the Edgar system. They're also available on the investor portals of these different companies. One of the things we're looking at is perhaps we have RSS feeds where we can automatically alert on 8Ks. Could we use AI to evaluate these 8Ks and look for commonality? So we're going to continue to work on this for you. And but in the meantime, write down what you're doing and test it.
Very, very good point.
If I could add one point, and I think, Donna, you actually brought this up during one of the sessions, and that is that we can't look at these incidents singularly either. If you've got related occurrences that are in their singular instance immaterial, if you look at them as an aggregate, and only related incidents, but if you look at them as an aggregate, you might have a material incident. So you just can't, you've got to be thinking about the boundaries of an incident as well.
Very, very good points. We're going to move on to the next topic. We can certainly wish we had more time, but again, we're looking at this in an ongoing basis with our task force meetings, and we're going to report on this again later this year as well. So this is a good point. So additional guidance that came out of this. We mentioned that maybe engaging the FBI may change the materiality determination, at least the reporting of it, because they may want to come in and look at this and say we need to hold off here and wait until we've done some investigations. One
But
thing
Tom, I do want to comment here that this is a
sure.
very narrow exception on the reporting. People are looking for, all right, how can we push that 4-day reporting rule out? Engaging law enforcement could possibly be delayed, but I want to make sure you understand that this provision is really pretty narrowly drawn. And I believe, Donna, did you throw it up in the chat? Perfect. Exactly. I want to make sure people realize that this is not a slam dunk, that you just don't automatically get this. So please recognize that it is a very narrow provision.
There's a form you file, there's a process for review. It's 30 days, it gets extended. But I think to clarify the statement, we mean engaging the FBI can help you request an exception, but engaging the FBI itself does not determine materiality or lack of
Right.
materiality. We're
Right.
talking as it relates to the clock here.
Right.
Yeah.
And,
Yeah, don't
yeah,
ever think that you shouldn't engage other partners. Whether it's trying to make a materiality determination or just trying to ensure that you get information shared or you're looking for information on how to deal with something. Like, for instance, if my team needed to contact FSISAC in order to figure out how to respond to something, I'm certainly never going to tell them, don't do that. You want to be able to engage with the people you need to engage with. All right. Don't feel like this is that, oh, just by engaging, you've made it material. You have not.
that's a very, very key point, and that's going to go definitely in our guidance document that comes out of that. You know, you have to resolve the incident. You have to do what it takes to do that, and not give a second thought to saying, if I do this, is it material? That's the worst thing you could do. But thank you for both for clarifying that. I was just going to say with these next 2 points that came out of it, and it was a lot of our discussions, Donna, that we had. We're going to be providing the information, but with this and all communications, especially this to the SEC, you really got to have a say in what's said here, just making sure that, I don't know if I say overstating or understating, but what is being stated is factual, and that you as a CISO can own up to it. Is that fair? I mean, the legal department's going to be writing this. They're going to be writing it with your input for sure.
Yeah, it's definitely a partnership with you, the legal department, perhaps finance and other stakeholders, maybe even other members of the disclosure committee, internal, external counsel.
Right.
I think the salient point here, Tom, is if you as a CISO are not engaged in this, it's going to be even more critical when we get to the next section and talk about cyber liability. So I happen to sit on the disclosure committee of my company. You may or may not. It's neither good nor bad, but think about the size of your company and whether you should be. And at a minimum, at least have the opportunity to, before they're published, to read those 10-Ks, because you're going to be on the hook to provide those control mechanisms that they stated in those filings. So it's very important that you agree and that your controls, as I said earlier, support those statements that are made in the 10-K. And in fact, you'll notice in Lockheed's, they don't say anything like best in breed, world class, because you can't evidence that. So
Right.
Just think about those kind of things and think about the impact on your personal liability, because you're on the hook for this, folks.
Thank you for saying that. Let me just move on to the last 2 points, and then we'll shift into the CISO liability, which we're being asked about in the remaining minutes of this webinar. Again, some people refrain from using the word incident. Depends on how, again, your own corporate decisions on this, but they might call it unauthorized activity. I've seen that word used a lot versus incident. Some will say incident directly, and some will report this in other events versus 105 cybersecurity incidents. I think that's kind of up to your team and how you're interested in doing this. By the way, there's a poll. Please take it if you would, folks. We value your feedback. But there are a lot of concerns that we've been talking about with over-reporting. Are we putting saying that something is an incident's not material yet, is it too much to do or too little to do? Now, I think the SEC is going to issue some guidance on this. We've been talking about it. We can't say anything specifically on it, but you as CISOs, what's your advice? Is it better to put more in and not? I mean, one of the concerns is if it's out there in the press and you don't put it in, maybe someone's going to call you out.
I think
What's your
everybody's going to
thought?
have a different view on this, Tom. I mean, I
Yeah.
think even Donna and I
Yeah.
will disagree depending upon the incident. But what I would say is that if everybody were to look at the 8Ks, and there are different services, as Donna mentioned, where you can take a look at the 8Ks that are cyber related right now. I would say, I mean, based on my quick view of the list that I have, 90% of them are basically saying, we don't know if it's material or not, but we're reporting anyway.
Yeah.
So I know, if you follow the letter of the law, letter of the regulation, it says 4 days after materiality has been determined. Nobody seems to be waiting for materiality to be determined to pull the trigger. People are actually filing these 8Ks saying, we don't know if this is material or not, but we're telling you about it.
Don't they
Overabundance of caution, some might
Yeah.
say overabundance.
Is-
Other people might say it's clear the lawyers are writing this.
So isn't there something about likely material in the regulation as well that's conflicting a little bit with that? Yeah.
Well, I think what they're addressing is we have other reporting obligations as publicly traded companies. We have other regulators. So I think in an abundance of caution, they're saying, well, if I'm going to report it to the AG or maybe report it to a particular state or a particular customer or a particular agency, I'm just going to go ahead and do it here. It's not one size fits all. There's not a lot of case law, anything here. So it's going to wash out eventually, and we'll get to some baseline. We're just not there yet because it's new.
Right, exactly.
So it's mileage is going to vary on this one greatly too. And as Jane said, I don't think any two CISOs are going to really agree on this because it's what's right for your company, your sector, your market cap, your investor pool, all this kind of stuff. So it varies.
Good point. I'm going to move on and I've just put this slide up saying that we do offer documentation, some guidance documents, filing examples, and we are having monthly task force meetings to continue on the discussion of materiality and new filings and how that affects things. So this is an ongoing process in which we're getting new information, and that new information is informing us. If you join the Cybersecurity Collaborative, remember you have the opportunity to see how we're all doing this. Coming back to a main point, it will depend on your organization to define materiality and how you want to do it. But to come back to as a CISO, you've got to be involved in those decisions. So we'll do a 90-degree flip here. I'm going to quickly put this up and let's move on to the guidance on that. The liabilities are, the spectrum is you're reprimanded, fired, personally sued, or convicted of a crime, even if you've left the company. I want to get into your discussion of this. I will put this up so people can read it. And again, when you get this presentation, you can use it as you see. Some of the situations, lying to regular criminal investigators is definitely a no-no. But what about proactively? I mean, how much do we need to proactively disclose? I mean, the whole truth to management legal department about the details, impacts, and root causes of an incident. It's as a CISO, we feel we have to protect the organization, even though it's the whole organization's responsibility under our leadership to do that. So when we have a major problem, we feel maybe we haven't done something right. But again, well, I think it's important to do that, establishing communicative relationship with counsel. Donna, you said keeping details of records of an incident, including email communications, very, very important, right? Because if you leave, and again, this comes up and you're called back, they want to ask exactly what happened. And then we'll talk about D&O in a second. But what are your thoughts on this?
Yeah, I think this really comes down to, and it's kind of similar to what I said earlier, document your process. do what that process says and evidence that process. And you'll likely be in good shape if you have a solid process and do what you say you're doing. The other thing is, the point made at the bottom about D&O. Are you covered under the D&O? Do you have advancement of legal expenses? What happens if you're separated, or is there severance? Is there a limit of liability? Can you be indemnified? So I think for those of you that are getting new CISO contracts, there's a whole list of stuff you should think about when you're looking for a job. I think those of you that are current CISOs, get a copy of your D&O insurance and see if you're named on it. Look at the date of that policy and what it covers. Talk to your boss about it if you feel comfortable doing that. But just make sure that you understand what protections the company offers you, whether or not you're an officer of the company. And that again varies company to company. I work in financial services. There's a lot of officers in financial services, but not all of them might have the same privileges, right?
Yeah. And the other thing is make sure you understand your corporate structure, because a lot of us have holding companies and things of that nature. So make sure you understand that and where you are in that officer layout. There were a couple of questions about how can you be on the hook for certain things if you're not participating in it. The outside world somehow thinks that CISOs are directing and telling everybody what's happening in cybersecurity, and that we have direct input into these 10Ks. So my advice to you all is to make sure that you get yourself involved wherever public statements are being made about your programs, whether that be cybersecurity. Some of you might also be DPOs, data privacy officers. If there are statements out there with regard to how you handle data and protect data and things of that nature, make sure you know what they are, because there's no settled law on this. We've got some cases going through, but there's not a body of law where I can tell you, based on this precedent, expect A, B, C, and D. It is completely shifting sands right now. But what we are seeing is the SEC and the regulators expecting the CISOs to be essentially on the same level they expect CFOs. When you think of like the big cases that caused reporting requirements for CFOs, Enron, things of that nature. This is the pivot point that we're seeing right now. I'm going to say that again. No settled law, but we're definitely seeing, if you look in the past, the same sort of movements that happened with CFOs.
Yeah, I would think Sarbanes-Oxley, right? But
yep.
I'd add, inclusive of what Jane said, I'd also add things like marketing materials, things like contracts. If you are the named individual accountable for security, doesn't matter if your title is CISO or not, to answer that question, I believe you could be on the hook, because if you are that named person, anything related to cybersecurity is then in your purview, whether or not you're aware of it or not. And that has yet to be proved out in a court of law, though there are a couple of cases that are active. So I'd be very careful. I'd review all of those materials that your company represents, the cybersecurity posture of the company, not just the case.
That's a very good point. So yeah, with Starbucks, I'm wondering if we're seeing, I thought about that, and I'm glad you pointed that out. It seems like we're moving in that direction.
I'm disappointed that they actually took the board expertise off the final rule, because that would have mirrored Starbucks a little bit more, where you now had financial experts with a seat on the board. But the problem with cybersecurity, besides the fact they got so many comments, and I think that certainly was applicable, but unless you're an active practitioner, having cyber knowledge could vary widely. So just because you supervise the team of a publicly traded company or not, or just because you had that in your purview, doesn't make you an expert. So I think, it's hard pressed to determine indeed what is a cybersecurity expert, right?
Well, in this field, that's a very, very good point, and you made it. Lastly, before we move on, and I appreciate you both for looking at the Q&As as we've gone along. That's really helped immensely. Again, CISOs, you got to look at your D&O insurance policy. These questions you should ask on the right, but it's extremely important. You can be added as a non-director or official officer of the corporation, but again, I urge you to do that in your acting role. And again, if you're looking to move into a new company, it's something you should negotiate for. All right, so I'm going to, so we can get to the rest of the questions. We're kind of at 5 minutes before close. I just want to mention that we do have other opportunities to engage on different security topics in the Cybersecurity Collaborative. I mentioned the CISO Power Hour on the first and third Thursdays of the month, where CISOs open up to each other about challenges they're facing and help each other out. Monthly on Thursdays, we have a security metrics team and an AI security team. And then on the first Thursday of the month, we have the SEC regulations and CISO liability team, a continuation of our discussions here. And again, a list of some of the task forces, security topics that we're engaging in this year is presented in the lower part of this particular slide. Everyone who's a member has access to a great library of materials, many of whom are directly contributed by our CISO organizations, others created in conversations in our task forces. We've covered most all security domains and are continuing to do that. It's useful for helping train your individuals, just getting some additional guidance in the practice areas that they're responsible for. So let's spend the last couple of minutes looking at any other Q&As. Thank you for taking the time today. I just want to say we'll get Q&A. Members have these materials posted in the portal over the next, we'll have them posted next week. And guests, please contact Tom Ward at cyberiskalliance.com for a copy of the presentation that has been in the Q&A box.
I'll handle a softball.
Questions out there.
We'll let you handle
the
all the tough
softballs.
questions. No.
So
thank you for the, yeah, go ahead. Yeah, we're getting some nice.
There's a real easy one, because you're going to hear this answer a lot from an attorney, which is it depends. How much is good D&O coverage? 1 million or what? I would tell you that it depends upon how big the liability might be. It's like with anything that you're going to insure. It really does depend upon the size, and you've actually got to talk to somebody who's really well versed in insurance. So that was a softball one. I like that one.
Well, I appreciate
and that's likely that's determined by your company too. The DEO coverage is not specific to a single officer; it would cover multiple. So it's likely that coverage would be relatively standardized. So that's not one that we'll have to worry about. What the point I was trying to make on D&O is just see if you're covered or not, and then if you're covered, understand the policy. You know, that's all.
Yeah, and then with regard to the layers, somebody asked, what if you have several layers between you and the CEO? As example, a CISO reporting to a CIO who then reports to the CFO. I have to address that one simply because I have to say I'm so sorry that you ultimately report to the CFO, because that's horrible. So in my opinion, what I would say there is that, and there was also a question about decentralized, and Donna, I think you touched on that as well. The regulators are going to look at whoever is responsible for the program, and that's it. It doesn't matter what the layers are. It doesn't matter how buried down you are or how close you are to the CEO. They're going to look at who's responsible for the program.
Yeah, in fact, I noticed in the last Fortune 500 CISO report, I think 100% of the Fortune ones had CISOs. 2 years ago, I don't even think it was 60%. So I think companies are looking at that too. They're actually formally naming an individual, and I think that's a trend that you're going to see continue. But there's got to be a named individual in every company, whether your title is CISO or not.
Yeah, think about the NYDFS requirements. I mean,
Exactly.
those regulations, you absolutely have to name somebody. So I don't know of any financial institution that doesn't have a CISO named.
Yeah, and then Lucy had a
Anyway,
good question about some of the qualitative attributes. Think
Right.
operational loss, whatever the dollar amount that's material to your company. On financial
reputation.
services, think number of records. So there's lots of quantitative operations impact, and then qualitative, as Jane said, those are a little more softball, relative to reputation and that kind of
Yeah.
damage.
Just
That was a good question.
we're at the top. Just a last thing here, and again, great questions and comments from our audience. Very much appreciated. The question about how do you tell the whole truth if it puts your direct manager or their manager in a tight spot? And
Always tell the truth. If you can't tell the truth, then it's time to look for another job. Yeah, we have options. We choose where we want to work, and if you work in a place where you can't tell the truth, it's unfortunate, but transparency is the key in our industry, and you have to be able to be transparent internally and with your board and other stakeholders.
And the bottom question is, when you're several layers down, reporting to a CIO, then reports to a CFO, still transparency. And the
Exactly.
problem is, if someone wants to minimize it, you don't. You have to step out and do the right thing. It's easier said than done. I know what that's like a little bit. So we're at the top of the hour, a little bit over. I want to thank everyone for spending the hour with us here. I hope you found it valuable. What was really valuable was having Jane and Donna on this call to embellish the work here, provide some cogent advice, and really come in and start asking your questions right during the presentation. You both are just amazing CISOs, and honestly, the leadership you provide to us and to everyone out there is greatly appreciated. So I really thank you for taking your time today and being with us, and obviously all the time you put in on this particular task force. Everyone have a great afternoon. Please reach out with a presentation and other questions, and we hope you will join us. Thanks, everyone. Take care.
Thanks, everyone. Appreciate.
Bye-bye now.
Bye-bye.